There's also excellent estate planning tools to protect assets after you have passed away. If you want to protect assets for your loved ones, maybe your children will inherit from you, maybe your spouse will inherit from you, the best way to do that is through use of trusts. Now, revocable living trusts can be used very effectively to protect assets for your children, for example. Maybe you are concerned that if your child inherits from you, now they own this money and now they get a divorce. And now all your money went to the divorcing spouse. That's a pretty common concern. Through use of trust, you can create a trust in your own revocable living trust, which becomes irrevocable on your death, or through your will, you can create a trust for your beneficiaries to protect them against threats. Threats being divorcing spouses, their own creditors, their bad lifestyle choices, as long as they're not their own trustee, that is. So anything you can imagine, anything that causes you concern about, if my child were to inherit from me, I'm worried that they're not going to make good use of that money or they're going to lose the money, etc. You can protect against that by making sure that whether you're using a revocable living trust or whether you're using a will, that you create a trust for that beneficiary. What if you have somebody who's going to be inheriting from you that's going to need government benefits? Maybe it's a special needs child. Same sort of situation. You want to create a trust for that special needs person. And again, it can be created through a revocable living trust or through a will. If you do this properly, the standard for the trustee to distribute money to that beneficiary is what we call a discretionary standard. Really, really important that this type of trust be a discretionary trust, as opposed to what's called a support trust. Sometimes in trust, you'll see health, education, maintenance, support. That's a support trust. If it's a special needs person or somebody who's on government benefits, it needs to be a discretionary trust. Why is that? Because then the government will look at that trust and they'll say, oh, it's a discretionary trust. The beneficiary cannot compel a distribution. And if they cannot compel a distribution, the government doesn't count that trust as belonging to the beneficiary. Therefore, have a discretionary trust if you want very strong protections to your beneficiary and the opportunity to allow them to keep getting their government benefits or to qualify for government benefits. And it also protects against creditors because a discretionary trust, creditors can't reach any of the assets in that trust. Now, I've been talking about how you protect your beneficiaries when you're gone, and you can do it through your own revocable living trust or your will, your last will and testament. There's one big exception here that is really important that we get that information out, at least in the state of Washington, is if you want to protect assets for your spouse when you are gone, and this is against long-term care costs so that they qualify for any government benefits to pay for their future long-term care, you must do so through your will. You cannot use a revocable living trust to protect assets for your surviving spouse when you're gone, because Medicaid won't honor any kind of trust that your revocable living trust created for your spouse. It feels like form over substance here, and perhaps it is, but it is very clear. Let's say that you and your spouse want to make sure you provide for each other, and like the majority of people who are older, you're concerned about long-term care costs. If that is your concern, that you want to make sure you provide for your spouse and that they would never become impoverished because they'll never have to spend down all of their money on long-term care costs, you have to use a will. You cannot use a revocable living trust. The will has within it a special kind of trust. It's that discretionary trust I was talking about. It's an asset protection trust. It's sometimes called a supplemental needs trust. And how it works is that both spouses have a will, and in the will has this trust. When the first spouse dies, their share of the couple's estate then funds this supplemental needs trust for the surviving spouse. All the assets in that trust do not count if that surviving spouse ever wants to apply for Medicaid.